Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
You know, when an engineer sets out to build a bridge, they rely on absolute measurable metrics.
Right. It's exact math.
Exactly. They run these really complex stress tests.
Yeah.
They calculate the tensile strength of the steel cables.
The load-bearing capacity of the concrete.
Yes, the exact wind resistance of the suspension design.
Mm-hmm.
They know, down to the decimal point, precisely how much pressure that structure can take before the microscopic stress fractures give way, the steel snaps, and the whole thing collapses.
Yeah, because it is a completely exact science. The breaking point is a mathematical certainty, you know? You can test it in a lab, you can model it on a computer, and you know exactly what the limits are.
But what happens when you shift from engineering a steel suspension bridge to engineering a human being's exit from a corporate workplace?
Oh, that's a whole different ballgame.
Right. Suddenly, all those visible, measurable stress tests just vanish. We aren't looking at math or physics anymore. We are looking at invisible, highly calculated psychological pressure points. Like, how much pressure does it actually take to snap a 26-year veteran employee? Corporate management often knows the exact formula, and they usually call it a performance improvement plan.
Yeah, they do. And it becomes incredibly murky and, frankly, quite dark. Because the breaking point of a dedicated long-term employee isn't something you can easily measure on a spreadsheet.
No, definitely not.
Yet corporate management knows exactly how to exploit that invisibility, to achieve their desired financial result.
Welcome to another episode of the Employee Survival Guide. Today, we are looking at the modern corporate workplace. Specifically, we are examining exactly how an employer can weaponize psychological pressure.
And that dreaded performance improvement plan, or PIP?
Right, the PIP.
Right.
Using it to systematically force an older, highly compensated employee out the door.
And we have a really fascinating, deeply instructive stack of legal documents to guide us through this reality today.
We really do.
Yeah.
So what are we looking at?
We are analyzing a federal civil complaint initially filed in 2022. Then we have the subsequent district court summary judgment from December 2023. And crucially, a brand new, incredibly pivotal decision from the First Circuit Court of Appeals that just came down in March of 2026.
Wow, okay, so this is fresh.
Very fresh. The case is Joanne Walsh v. HNTB Corporation.
Now, at its core, this is the story of a 26-year veteran of an IT department who, spoiler alert, ultimately lost her legal battle.
Yeah, unfortunately she did.
But, we aren't just here to recount a courtroom loss or to read through a legal textbook. The true value of this case, the reason we are spending the next hour or so dissecting every single maneuver, is what it teaches you, the listener.
That is the crucial takeaway here. This case is an absolute masterclass in what not to do when you find yourself targeted by management.
Exactly.
It is a cautionary tale, yes. But more importantly, it provides the foundation for clear, actionable, and proactive strategy to beat a PIP. Joanne Walsh fought incredibly hard, but she fell into these legal traps that you really need to know how to avoid.
Okay, let's unpack this. Let's wind the clock back, way back.
Before the lawsuits.
Right, before the tension, before the PIP, just to understand exactly who Joanne Walsh was and the immense value she brought to her company. So, Joanne Walsh was hired by HNTB Corporation at the very end of January 1994. Now, for context, HNTB is a major infrastructure design firm.
Right, they design bridges, highways, massive public works projects.
Yeah. And Walsh was hired as a computer support analyst for their Boston office.
And to really understand the scope of her competence, we have to talk about what it meant to be a computer support analyst in January of 1994.
Oh, man, right. Think about the technological landscape of 1994.
It was a completely different world.
We are talking about a world before widespread broadband. We are talking about dial-up internet, floppy disks.
Beige tower computers with those massive CRT monitors.
Yes. The novel NetWare, Windows 3.1, the very dawn of widespread corporate email.
Exactly. And to survive and thrive in a corporate IT department from 1994 all the way into the 2020s, that requires an almost unimaginable amount of cognitive adaptability.
You're constantly learning.
Constantly. She had to navigate the transition to Windows 95, the panic of Y2K.
Oh, Y2K.
The dot-com bubble burst, the complete shift from local physical servers to cloud computing.
The introduction of smartphones.
Right. Remote desktop support, the explosion of software as a service.
It's essentially having to learn a completely new profession every 3 to 5 years for over 2 decades.
That's a great way to put it.
And by all accounts in the legal record, she did this flawlessly. She was eventually promoted to a Technology Support Representative 2, or TSR2.
And what did that entail?
Her job was to support the company's IT systems, assist engineers and architects with their daily technology needs, and manage equipment and leases for multiple offices in the Boston area.
And for over 20 years, from 1994 all the way through 2015, her personnel file was immaculate.
That's what?
No negative evaluations, no letters of concern, no disciplinary actions whatsoever. She received an annual merit increase every single year.
Why?
Every year. Every year. She was a known, highly reliable quantity. She was literally the institutional memory of that IT department.
But then we hit the catalyst, the turning point where loyalty and competence suddenly become, well, liabilities.
Yeah, this is where things start to turn.
Between 2015 and 2017, Walsh's supervisor at the time, a man named Kevin Welsh, started pushing her to consider advancing to the next tier, the TSR3 position.
And this is where Walsh makes a decision that in a rational, healthy ecosystem should actually be celebrated.
Right.
She declines the promotion. She tells her supervisor, I am very happy in my current role as a TSR2. I enjoy the work. I am highly proficient at it. And I don't want to change my job description to take on the different responsibilities of a TSR3.
Which introduces this really fascinating and frankly toxic corporate dynamic. Something I kind of think of as the contentment penalty.
Ooh, I like that term.
Because we all know the Peter principle, right?
Right.
The idea that people in a hierarchy tend to rise to their level of incompetence. Like, you keep getting promoted because you are good at your current job until you land in a management job you are terrible at.
And then you just stay there.
Exactly, making everyone miserable.
Right. It is a well-documented and deeply flawed phenomenon in organizational psychology. We reward good coding, for example, by making the coder a manager of other coders.
Even if they have zero management skills.
Exactly.
So here we have Joanne Walsh, an employee who possesses incredible self-awareness. She recognizes her strengths.
Right.
She essentially says, I am excellent at this specific job. I bring massive value to the company right here. I do not want to rise to my level of incompetence.
Right.
So why does modern corporate culture aggressively punish an employee simply for wanting to stay in a role they have completely mastered?
What's fascinating here is it comes down to the financial calculus. And this is exactly where the seeds of age discrimination are planted. Well, what happens when you stay in a role for 20 plus years? You naturally accumulate raises.
Sure.
Even small, incremental 2 to 3% merit increases compound significantly over a quarter of a century.
So she starts bumping up against the ceiling of what the company thinks a TSR2 is quote-unquote worth.
Precisely. The psychological shift within management is profound here. They stop viewing you as an experienced, reliable asset who keeps the lights on and the systems running.
Yeah.
Instead, they start viewing you through a purely financial lens as expensive, overpaid liability. Management looks at a spreadsheet and thinks, we are paying premium dollar for a TSR2. We could bring in someone fresh out of college, pay them half as much, and get the same basic function.
Even if that new hire doesn't have the 20 years of institutional knowledge on how to fix the specific legacy server that the Boston office relies on.
Exactly. To the spreadsheet, a TSR2 is just a TSR2, and that is the exact soil where age discrimination takes root. The company wants to reset the salary band.
And the repercussions for Walsh's contentment were immediate. Her supervisor told her that because of how long she had been with the company, she was at the top of her salary range.
Which, interestingly enough, she later learned from another manager wasn't entirely true.
Wait, really? It was a lie.
Yeah, there was still room in the band, or at least the possibility of market adjustments. The salary cap was, in many ways, an artificial pressure tactic.
Wow. But the narrative was set by management. She was explicitly told she wouldn't receive any further raises unless she took that TSR the third role.
Yep.
And true to their word, HNTB stopped issuing her annual merit increases. They broke a consecutive streak of raises that had lasted since 1994.
They capped her earning potential as a direct penalty for her contentment. They were squeezing her financially, hoping she would either take the new role, which would justify the higher pay, or just get frustrated and leave.
But she doesn't leave. She absorbs the financial hit and just keeps doing her job.
Yeah, she stays.
In fact, in April of 2019, she gets a new direct supervisor, a guy named Jim Clark. He comes to the Boston office, conducts her annual review, and the record shows it is largely positive.
Okay.
He tells her she is well-respected, she works hard, and he explicitly tells her to keep up the good work.
Keep that timeline in mind, though. April 2019. Keep up the good work. Because a modern corporate environment rarely tolerates an expensive veteran for long. Just 4 months later, the trap is sprung.
Right. On August 1st, 2019, out of absolutely nowhere, Joanne Walsh is placed on a 90-day performance improvement plan.
Out of nowhere.
And notably, she isn't the only one targeted. Her colleague, Lindsay Allenson, the only other TSR2 supporting the Boston office, who happened to be 62 years old at the time. Yeah, she was placed on an almost identical PIP on the exact same day.
Two women, aged 55 and 62, the senior IT staff for the entire office, suddenly slapped with identical improvement plans out of the blue.
I mean, the optics are terrible. We need to look at the actual text of this PIP because it is incredibly revealing about how these documents are weaponized.
Yes, let's look at the wording.
The PIP didn't say, your network uptime has dropped to 95% and we need it at 99%. No. It claimed she was contentious. It claimed she pushed back on suggestions and was unwilling to look for solutions. It actually formally criticized her for, quote, hiding in the IT room.
Which, as anyone who has ever worked in a corporate office knows, is an amazing critique for an IT professional.
Right. I mean, where else is the IT person supposed to be? The roof, the cafeteria, their entire job lives in the server room.
Exactly.
It also criticized her for having a messy office that supposedly made it difficult for employees to access IT resources.
When you analyze the language of this specific PIP, and honestly so many PIPs like it, you realize it is completely devoid of objective, measurable metrics.
Right, there's no data.
A genuine performance improvement plan one, actually designed by a healthy HR department to help a struggling employee succeed, relies on quantifiable data.
Like what?
It says, you are currently closing 10 IT help tickets a day. We need you to close 15. Or, your software deployment error rate is at 4%. We need it down to 2% within 60 days.
Because with a metric, the employee knows exactly what the finish line looks like.
Exactly.
But how do you measure contentious? How do you quantify unwilling to look for solutions?
You can't. And that is the entire point of a weaponized PIP.
Yeah.
These are highly subjective, personality-based critiques. They are designed to be entirely fluid. If a manager wants you to fail a PIP based on being contentious, you will fail it because any clarifying question you ask can just be framed as pushback.
Oh, wow.
Yeah. It is an unwinnable scenario designed not for genuine professional growth, but solely to create a legally defensible paper trail for termination.
And the ageist overtones during this 90-day period were just screaming out loud. Because Walsh, being a 26-year veteran, didn't just take this lying down.
Right. She pushed back.
She tried to understand the sudden, bizarre shift in her reality. She went to her supervisor, Jim Clark, the guy who just 4 months earlier told her to keep up the good work.
The guy who wrote the PIP.
Exactly. And she asked him a very basic logical question. Who is complaining about me? Give me the names or the specific instances so I can address the feedback and fix the problem.
And how does management respond to a targeted employee asking for the specific data they need to comply with the PIP?
Well, according to the record, Clark was visibly pissed that she kept asking.
Wow.
His exact words to her, his subordinate of 26 years, were, stop asking, stop talking to people, shut up.
Shut up. That is a direct quote from the record.
I have to pause here because this is maddening. I mean, here's where it gets really interesting.
Yeah.
If the stated, documented goal of a PIP is genuinely to improve an employee's performance, why in the world would a manager tell an employee to shut up when they ask for the specific feedback they need to make those improvements?
It makes no sense.
It makes zero logical sense.
It shatters the illusion of the PIP's legitimacy entirely. It reveals to anyone paying attention that the document is a weapon, not a tool.
Right.
When a manager tells you to shut up while you are on a PIP, they are implicitly telling you this isn't about you getting better. This is about you going away.
And it gets even more explicit. During this PIP period, another longtime IT employee named Dan Veely was brought in as her team leader.
Okay.
He was supposedly responsible for mentoring her, for helping her successfully navigate and complete the plan. But instead of mentoring her, Veely tells her explicitly, the company is not getting its return on investment for you.
He essentially verbalized the silent spreadsheet calculus we talked about earlier.
But he went further than that. He told her point blank that she could be replaced with younger, cheaper people.
Let's stop right there.
Yeah.
In employment law, particularly under the Age Discrimination and Employment Act, the ADEA, that phrase is the holy grail for a plaintiff. It is the absolute smoking gun of age discrimination. Younger, cheaper people. It perfectly encapsulates the toxic dynamic. The company no longer valued her 26 years of institutional knowledge. They only saw the premium salary attached to her age and tenure.
So they just wanted her out.
Right. They weaponized the PIP to try and break her spirit so they could swap her out for a cheaper model. Congress literally passed the ADEA in 1967 to stop exactly this kind of financially motivated ageism.
But here is the incredible twist in Joanne Walsh's story. She didn't break.
She didn't.
Despite the entirely subjective critiques, despite being told to shut up by her boss, despite the blatant illegal threats of being replaced by younger, cheaper labor subversiveness, she put her head down, did the work, kept her mouth shut, and successfully completed the PIP in November of 2019.
She beat the trap.
Yeah.
Even Dan Veely had to admit she passed the requirements of the 90-day window. And Jim Clark concurred, though he couldn't resist a final petty dig, telling her she had barely improved enough to get off the PIP.
Unbelievable. So she survives. The 90 days are over. But surviving a PIP doesn't mean the company forgives you for staying.
No, it rarely does.
Because shortly after she passed the PIP, Dan Veely, the guy who explicitly threatened her with younger, cheaper replacements, was officially promoted to be her direct supervisor.
Which shifts the corporate strategy from an acute attack, the PIP, to a chronic war of attrition.
So Veely takes over the Boston IT department in late 2019. And the environment over the next 10 months transitions from hostile to just a grinding psychological torture chamber.
Yeah.
The legal record shows he micromanaged Walsh and Allenson relentlessly. He would assign them complex IT projects, swoop in and take all the credit with upper management when things went perfectly.
Naturally.
Right. But the second a project hit a snag, he would suddenly vanish and dump the entire responsibility back in their laps.
It is classic textbook gaslighting management. It keeps the employee entirely off balance. You are constantly anxious about where you stand, constantly waiting for the other shoe to drop, constantly second-guessing your own competence.
She also testified that Veely systematically infantilized her. Remember, she has been running this IT infrastructure since 1994.
Yeah, she knows her stuff.
She knows what the company's servers and software can and cannot do. But Veely instituted a humiliating new rule where she was no longer allowed to simply say no to impossible or unreasonable IT requests from other staff members. She had to tell the requesting employee she would check with her supervisor, physically go get Veely's permission, and only then could she deny the request.
You have to understand the psychological damage that inflicts. For a highly competent veteran employee, that is deeply degrading.
I can't even imagine.
It strips away your professional autonomy and signals to the rest of the company that you are no longer trusted to make even the most basic decisions in your own specialized field of expertise. It is a public demotion in status, even if the title remains the same.
The record says he would yell at her, telling her he was the manager and could tell her anything he wanted.
Typical power trip.
Yeah. He pressured her to respond to IT tickets faster than ever before, creating an artificial pressure cooker. He constantly made mountains out of molehills. And all the while, he was visibly, loudly praising the younger IT staff in other offices while completely ignoring the exact same caliber of work being done by Walsh and Allenson in Boston.
Day in and day out, week after week, month after month, this is the drip, drip, drip of psychological pressure.
Yeah.
Management knows they missed their shot to fire her with the PIP, so the new goal is to make the work environment so profoundly uncomfortable, so deeply anxiety-inducing, that the employee eventually decides the paycheck is simply no longer worth the emotional and physical toll.
And eventually, tragically, the strategy worked. On September 11th, 2020, which is exactly 10 months after she successfully completed the PIP, Joanne Walsh and Lindsay Allenson reached their breaking point.
Yeah.
At a combined tenure of over 4 decades of service to this company, they both simultaneously resigned. They just quietly walked out of the HNTB Boston office together.
And that quiet walkout is the hinge upon which this entire legal case and the lesson for you, the listener, swings.
How so?
Because Walsh didn't just walk away to retire. She immediately sued HNTB for age discrimination under both the Federal Age Discrimination in Employment Act and Massachusetts state law.
Oh.
And her core legal argument rested on a concept known as constructive discharge.
Okay, we need to spend some serious time here unpacking the mechanics of this.
Yeah.
Because it is vital. What exactly is a constructive discharge?
All right.
Because to a layperson, to anyone listening to this right now, if my boss treats me terribly, screams at me, infantilizes me, and threatens to replace me until I finally break down and quit, that feels exactly like I was fired.
It absolutely feels that way. And morally, you could argue it is the exact same thing. But the legal standard for constructive discharge is incredibly, notoriously rigorous.
Okay.
To win a constructive discharge claim, an employee cannot just prove that their boss was a jerk or that the workplace was highly stressful or even that the manager was unfair.
So what is the bar? What do you have to prove?
You have to prove that the employer deliberately made the working conditions so onerous, abusive, or unpleasant that a reasonable person in your exact shoes would feel absolutely compelled to resign.
Wow.
You essentially have to prove that you were stripped of your free will, that quitting wasn't a choice, but an absolute necessity for self-preservation.
The courts have a very specific, almost poetic phrase they use to describe what doesn't count as constructive discharge, right?
Yes. And you see this language in almost every appellate decision on the topic. The courts frequently state that federal anti-discrimination laws do not guarantee a workplace free from the usual ebb and flow of power relations and interoffice politics.
Oh, come on.
Yeah. You are expected legally to endure what the courts call the ordinary slings and arrows that workers routinely encounter in a hard, cold world.
Let me jump in here because I have to push back on this underlying logic.
Go for it.
Wait, isn't a boss literally telling you they can replace you with younger, cheaper people? The definition of an abusive environment. I understand the courts don't want to be dealing with every minor office spat, but ordinary slings and arrows. How is that an ordinary sling and arrow? Why is the justice system protecting that kind of corporate behavior?
It's a great question, and it gets to the heart of why employment law is so frustrating for plaintiffs. The courts enforce this astronomically high bar because they are terrified of becoming what they call a super HR department.
A super HR department.
Right. Federal judges do not want their dockets clogged with every employee who feels slighted, passed over, or micromanaged. They reserve constructive discharge for the most extreme, physically or psychologically unbearable situations.
Okay, but even with that high bar, she had the smoking gun, she had the younger, cheaper comment.
In a vacuum, yes. Those comments are highly indicative of age-based animus. If she had been fired the day after he said that, it's a slam dunk case. But in the context of a constructive discharge claim, the court doesn't look at comments in a vacuum. They look at the entire timeline. And this brings us to the fatal flaw in Walsh's legal strategy.
What happened?
She lost this argument in the district court in 2023, and she lost it again at the First Circuit Court of Appeals in 2026. The fatal flaw was the timeline of her endurance.
The 10-month gap.
Exactly. The most egregious, explosive comments, Clark telling her to shut up, and Veely making the younger, cheaper threat, those happened in August or September of 2019 during the PIP window.
Right.
But Walsh didn't resign then. She put her head down, finished the PIP, and continued working under Veely for another 10 full months until September 2020.
So I'm guessing the court views that endurance as a waiver. They probably look at that timeline and think, if the environment was truly intolerable, if you were genuinely stripped of your free will, you wouldn't have lasted another 300 days.
Exactly.
It's like bleeding out slowly instead of all at once, and the court only seems to care if you bleed out immediately.
That is a perfect analogy. The court explicitly ruled that comments made 10 months prior cannot logically be the immediate compelling catalyst for a resignation today. The fact that she stayed for almost a year acts as a legal waiver of the immediate severity of those comments.
So her entire legal case rested not on the explosive ageist comments, but on what happened after the PIP ended. The daily micromanagement, the infantilizing permission structure, the credit stealing by Veely.
Precisely. And while we can all agree that Veely sounds like an absolute nightmare of a manager, the courts looked at his post-PIP behavior and categorized it as generally disagreeable behavior and ordinary slings and arrows.
Unbelievable.
It was bad management, certainly, but it wasn't legally intolerable.
But there is a critical, tragic procedural detail from the source documents that we have to discuss. It's a massive lesson for anyone involved in litigation. When Walsh's attorneys filed their opposition to HNTB's motion for summary judgment, they made a fatal error.
Yeah, we need to explain summary judgment briefly.
Please do.
Summary judgment is the put up or shut up phase of a lawsuit. Before you ever get to a jury, the company files a motion saying, "Judge, even if everything the plaintiff says is true, she still doesn't have enough legal evidence to win, so throw the case out now."
Right. And to survive that, The plaintiff's lawyers have to lay out all their best facts.
Right.
But in this case, Walsh's lawyers focused heavily on the PIP period and those explosive, younger, cheaper quotes. They essentially glazed over the daily, grinding psychological pressure of those final 10 months. They didn't elaborate on the specific facts that made her feel so unwelcome that she had to quit.
It is a profound procedural tragedy. In a summary judgment proceeding, the judge is not an investigator.
They only look at what's in front of them.
Exactly. The court can only rule on the specific facts that are explicitly laid out and argued in the legal briefs. If your lawyer doesn't elaborate on the daily specific instances of abuse, the exact dates, times, and nature of the micromanagement that drove you out the door in September 2020, the court cannot consider it.
By failing to meticulously document and argue the severity of those last 10 months in their legal filings, she legally waived that critical context.
Yep.
She gave the judge an incomplete picture of her daily suffering. And based on that incomplete picture, the judge did what judges do. Summary judgment granted for HNTB. Case dismissed. You lose.
And for the vast majority of people, that is where the story ends. Litigation is exhausting.
It really is.
The money runs out, the emotional toll of rehashing your trauma is too high, and they just walk away quietly.
But Joanne Walsh did not go down without a fight. After losing in the district court, Walsh's trial counsel actually dropped her. They told her their firm didn't handle appeals.
Wow.
So picture this. She is sitting there in early 2024. She lost her career of 26 years, she lost her federal case, and now she has lost her lawyers. The clock is ticking on a strict 30-day window to file a notice of appeal to the First Circuit.
And this is where you have to deeply admire her grit and her courage. She refused to give up. She decided to fight in federal appellate court as a pro se litigant.
For you listening, pro se means representing yourself, without a lawyer. Going up against a massive corporate law firm entirely by yourself.
Right. She files a handwritten motion herself, asking the court for an extension of time to file her appeal so she can try to find a new attorney.
And she gets the extension.
She does.
She eventually files her formal notice of appeal in May of 2024. Now, predictably, HNTB's highly paid corporate appellate lawyers immediately tried to get her appeal thrown out on a technicality. They argued she missed the strict 30-day window for the formal notice, regardless of the extension.
But the First Circuit Court of Appeals did something quite rare and gracious here.
What's that?
They applied a legal doctrine where they liberally construe filings by pro se litigants. They looked at her initial amateur request for an extension, noted that it named the parties, and showed a clear, undeniable intent to appeal the summary judgment.
Okay.
And they ruled that her handwritten motion was the functional equivalent of a notice of appeal. They allowed her case to be heard on the actual merits, defeating the corporate lawyer's technical trap.
It was a massive procedural victory. And as her appeal is winding its way through the system, something even bigger happens. A seismic shift in employment law occurs at the United States Supreme Court that seemed perfectly, almost miraculously timed to save her case.
Yes. In April of 2024, the Supreme Court issued a landmark ruling in a case called Muldrow v. City of St. Louis.
We need to spend some time unpacking Muldrow because it fundamentally changes the landscape of what we are talking about today.
Absolutely. To understand Muldrow, you have to understand the old rules, the rules the district court used to dismiss Walsh's case.
Right.
Historically, to prove discrimination, an employee had to show they suffered a materially adverse employment action. You had to prove the employer did something that caused a significant, severe economic or professional change in your job, firing you, demoting you, or cutting your pay.
Right. The old standard required real economic blood on the floor. If they just made your life miserable but kept your title and pay the same, courts often said, no material harm, no foul.
Exactly.
But then comes Officer Jatonia Muldrow.
Exactly. Officer Muldrow worked for the St. Louis Police Department in the highly prestigious Intelligence Division. She worked plainclothes, she had FBI credentials, an unmarked car, a steady Monday through Friday schedule.
Sounds like a great gig.
It was. But a new commander came in, allegedly wanted a male officer in that role, and transferred Muldrow out of intelligence and into a standard uniformed patrol district.
But here's the catch. Her rank stayed the same, and her pay stayed exactly the same.
Right. And because her pay and rank didn't change, the lower courts threw out her discrimination lawsuit, saying she didn't suffer a materially adverse action.
But the Supreme Court took the case and completely threw that old standard out the window. Justice Kagan wrote the opinion, and they lowered the bar significantly. They ruled that an employee no longer needs to show a material or significant harm. You only need to show that the employer's discriminatory action left you worse off with respect to the terms or conditions of your employment.
Worse off. That is a completely different universe of legal protection.
It really is.
It's the difference between requiring a broken leg versus requiring a deep paper cut. The Supreme Court said that losing her unmarked car, losing her FBI status, and having to work weekend patrol shifts clearly left Officer Muldrow worse off, even if her paycheck was identical. That was enough to constitute an adverse action.
So cut back to Boston. Joanne Walsh's new appellate team argues this exact standard to the First Circuit. They say, look at Muldrow. Look at this PIP. She was falsely accused, harassed, told to shut up, threatened with being replaced by younger, cheaper people, and subjected to a hostile 90-day interrogation. Even if her pay didn't drop during those 90 days, she was clearly left worse off by being placed on this discriminatory, weaponized PIP.
It seems like a slam dunk winning argument under the newly lowered standard. She was objectively worse off having to navigate that psychological minefield.
But the legal system is full of dark surprises. In March 2026, the First Circuit Court of Appeals ruled against Joanne Walsh yet again. And their reasoning is what makes this case a dangerous, terrifying new reality for employees everywhere.
The First Circuit engaged in some incredible legal gymnastics to sidestep Muldrow.
What did it do?
They looked at the specific facts of Walsh's PIP. They noted that the PIP document itself did not assign her new duties, it did not alter her job title, it did not reduce her compensation, and it did not explicitly limit her ability to seek other roles in the company.
So because of that,
because she successfully completed it without losing pay or rank, the court ruled that the PIP, legally speaking, was merely documented counseling.
Documented counseling.
Yeah.
They completely sanitized a weapon of psychological warfare.
Yep.
They looked at a document designed to create a paper trail for her termination, accompanied by a manager telling her she would be replaced by younger, cheaper people, and they called it counseling.
It is a chilling decision, because if we connect this to the bigger picture, this case is now a dangerous, bad precedent for older workers in that jurisdiction. The First Circuit essentially ruled that even under the lowered Muldrow-Worsoff standard, a PIP is not inherently an adverse employment action based on these facts.
So what does this all mean for you if you get handed a PIP tomorrow? An employer can force you through 90 days of subjective, unwinnable critiques. They can hurl veiled threats at you, infantilize you, make you miserable, and as long as they don't explicitly touch your paycheck during that 90-day window, they haven't legally harmed you. It's a massive loophole.
It is a roadmap for corporate HR departments on how to legally harass older workers out the door without triggering an adverse action.
Which leads us directly to the most important part of this entire discussion. If you are sitting at your desk tomorrow and your boss calls you into a room and hands you a 90-day PIP filled with vague, unquantifiable complaints about you being contentious or not a team player, what do you do?
Right. What's the plan?
Because Joanne Walsh tried to survive it. She tried to endure the aftermath. She finally walked away to protect her own sanity, and the courts told her she had no case.
This is why we study these losses. We are extracting the proactive playbook. Based on the failures, the legal traps, and the dangerous new precedents exposed in the Walsh case, we have a clear, step-by-step employee survival strategy to beat the PIP every single time.
Get ready, because this is the playbook. Lesson number 1, and this is the absolute golden rule of surviving the modern workplace. Do not ever quit.
Never. No matter how bad you think the psychological pressure is, no matter how much your manager is micromanaging you, yelling at you, or gaslighting you.
Just don't do it.
Walsh's case proves unequivocally that arguing and winning a constructive discharge case is nearly impossible. The legal bar for proving that you were compelled to resign is simply too high. Courts expect you to endure an unreasonable, almost inhumane amount of misery. If you voluntarily walk out that door, you are surrendering almost all of your legal leverage. You are doing their job for them.
It feels empowering in the movies, right? To slam your badge on the desk, tell your boss off, and walk out with your head held high. But in a courtroom, that dramatic exit means you just signed away your only leverage. Which brings us to lesson 2. Always let the employer fire you.
It sounds completely counterintuitive. We are socially conditioned to think getting fired is the ultimate professional failure, a permanent stain on our resume.
Right.
We'd rather resign to pursue other opportunities to save face. But legally, under the Muldrow standard we just discussed, a termination is the ultimate, undeniable, bulletproof, adverse employment action.
It is the silver bullet. Think about it. If HNTB had simply fired Joanne Walsh, there would be zero debate at the First Circuit about whether she suffered an adverse action.
None at all.
she would have sailed past that summary judgment hurdle. By walking out quietly, Walsh robbed herself of the exact legal trigger she needed to win her case.
She had the early ammunition. She had the documented lack of pay raises despite stellar reviews. She had Clark telling her to shut up when she asked for witnesses. She had Veely's explicit age animus comment about being paid too much and being replaced by younger, cheaper people.
She had so much.
She did. But because she couldn't take the daily psychological pressure, and because her lawyers failed to elaborate on that pressure in the summary judgment argument, she waived it all by quitting.
So the rule is, make them pull the trigger. Make them own the decision to end your livelihood. Because when they do, they are on the hook in federal court for proving it was a legitimate, non-discriminatory firing, which is incredibly hard for them to do when you have a paper trail of ageist behavior.
Okay, though we have to address the reality of this advice. You don't quit, you stay. But how do you actually survive the daily psychological warfare of a PIP while you are waiting for them to make a move? You can't just sit there and absorb the abuse for a year like Walsh did.
Exactly. This brings us to lesson 3, the proactive strategy to actually beat a PIP and turn the tables on management. We call this the insurance strategy, and it requires you to be aggressive.
Here is the step-by-step breakdown. Step 1. The moment the very first ageist or discriminatory comment happens, for example, the moment Dan Veely says, "We can replace you with younger, cheaper people," you do not wait. You do not brush it off. You immediately file a formal written discrimination claim internally with human resources.
But wait, let's role play this for a second. If you are the employee and you go to HR, aren't you just putting a massive target on your back? Everyone knows HR works to protect the company, not the employee. If I complain, won't they just accelerate my firing?
That is the exact fear that keeps people silent, but it fundamentally misunderstands how corporate liability works. Yes, HR works for the company, but their job is risk mitigation. When you send an email to HR, BCC your personal email address and state clearly, "On this date, my manager made a discriminatory comment regarding my age and my salary, and I am formally reporting this." You have just created a legally protected record.
Okay, but let's say HR does what HR usually does, which is sweep it under the rug, and a few weeks later, management suddenly places you on a weaponized PIP. This is where step 2 kicks in, and it is the most crucial maneuver of all.
Pay attention to this part.
If placed on a PIP, immediately file an external complaint with the EEOC, the Equal Employment Opportunity Commission, while you are still actively on the PIP.
Do not wait until the PIP is over. Do not wait until you fail it. File the federal complaint while you are sitting in the middle of that 90-day window.
Why? What does filing that piece of paper actually do?
It acts as a legal force field. When you file an EEOC complaint alleging discrimination, you immediately trigger federal retaliation protections. You are essentially buying legal insurance for your job. Corporate lawyers and HR departments are absolutely terrified of retaliation claims.
Because retaliation claims are actually much, much easier to win in front of a jury than the underlying discrimination claims.
Exactly. Even if you can't perfectly prove the initial age discrimination, if an employer fires you shortly after you file a formal EEOC complaint, the court heavily presumes the firing was retaliation for the complaint itself.
Wow.
It doesn't matter what performance issues the employer claims you had on the PIP, the optics of firing a whistleblower are toxic to a corporation.
So, by filing that EEOC complaint while on the PIP, you force the employer's hand. If they proceed to fail you on the subjective PIP and fire you, they are walking straight into a highly winnable retaliation lawsuit. They're essentially handing you a winning lottery ticket.
Which means in 99% of cases, they won't do it. The corporate lawyers will look at the situation, see the EEOC complaint, and tell the rogue manager, back off immediately. We cannot fire this person right now. It looks like textbook retaliation.
They bump the brakes.
This strategy forces the employer to freeze. They usually back off for 5 to 7 months before they feel legally safe enough to take any further action regarding your performance issues or their psychological adverse office behavior.
You have literally bought yourself half a year of breathing room.
But you do not just sit back and relax during those 5 to 7 months. This brings us to the final step of the strategy, the documentation offensive. You document the absolute shit out of everything that happens in that office.
You need to develop what lawyers call an ongoing narrative affidavit. This isn't just a casual diary where you write, "My boss was mean today." This is a contemporaneous, highly detailed forensic record of every single interaction with the manager who is targeting you.
Tuesday, 9:00 a.m., Manager Veely demanded I complete a 4-hour server migration task in 30 minutes, yelled at me in front of 3 witnesses, and refused to provide the necessary software access. You write down the exact date, the exact time, the names of the witnesses, and the exact words spoken.
And here is the absolute kicker, the way you win the game. If the manager continues to apply psychological pressure during that 5 to 7 month freeze, if they start micromanaging you worse, stealing your credit, isolating you from the team, you take that new documentation and you file additional discrimination and retaliation claims internally and externally based on that ongoing pressure.
You completely and utterly frustrate the employer. You bury them in their own liability.
That is the ultimate goal. You are taking the weaponization of the PIP and turning the paperwork back on them. By building this ironclad fortress of documentation and federally protected complaints, you force the corporation into a corner.
Yep.
They only have 2 choices left. They must either get the rogue manager in line, back off entirely, and help you do your job in peace, or they get so frustrated by your legal force field that they force your termination anyway.
And if they foolishly choose termination, they have just handed you the exact adverse employment action you need under Muldrow, wrapped in a beautiful bow of documented retaliation, setting you up for a massive legal victory.
It's brilliant.
It requires immense fortitude, though. It is not easy to stay in a hostile environment and forensically document your own abuse, but it is the only proven proactive strategy employees have to beat the PIP every single time.
We have covered a tremendous amount of vital ground today. Let's do a quick recap to solidify this. We looked at Joanne Walsh's incredible 26-year run at HNTB, a career defined by extreme adaptability and competence that was derailed simply because she was content in her role and her salary grew too large for management's liking.
Yes.
We watched how a subjective, unwinnable PIP was used to break her resolve, leading to her quiet, legally fatal walkout.
We also highlighted her extraordinary courage to fight as a pro se litigant at the federal appellate level, securing her right to be heard even after her trial lawyers completely abandoned the case.
And while she unfortunately lost at the First Circuit, the reality is she should absolutely appeal this to the U.S. Supreme Court. The First Circuit's ruling that a weaponized PIP is merely documented counseling and not an adverse action under the new Muldrow standard sets a chilling, dangerous precedent for older workers everywhere. It is a massive legal loophole that corporations will exploit relentlessly unless the Supreme Court steps in to close it.
And until they do, you must remember the playbook. Never quit. Let them fire you. Buy insurance with an external EEOC complaint while on the PIP, document every single interaction, and file continuous claims to frustrate their efforts.
Which brings us to a close, but leaves us with a critical thought about the true nature of the invisible stress tests of the modern workplace.
We want you to think about this long after this audio ends. In the modern corporate landscape, with everything we've just uncovered, is a performance improvement plan actually designed to improve your performance? Or has it fully evolved into a highly optimized, legally sanitized weapon designed specifically to apply just enough psychological pressure to make you inflict the fatal wound on your own career by quitting?
Thank you for tuning in to this episode of the Employee Survival Guide. Remember to stay informed, document the absolute life out of your workplace, and never, ever give up your leverage. We'll see you next time.
Hey, it's Mark, and thank you for listening to this episode of the Employee Survival Guide. If you'd like to be interviewed for our podcast and share your story about what you're going through at work, and do so anonymously, please send me an email at mcarey@capclaw.com. And also, if you like this podcast episode and others like it, please leave us a review. It really does help others find this podcast. So leave a review on Apple or Spotify or wherever you listen to this podcast. Thank you very much, and glad to be of service to you.